We understand this is a confusing and scary time for your family. We have developed this presentation to give you some important information that you will need in the coming weeks and months. This handbook is intended to educate parents and legal guardians who are entering the juvenile dependency system for the first time. Included are explanations of the court process, as well as different court hearings and the role of each social worker. Not all situations are covered in this handbook, and you are encouraged to seek additional information from your social worker and/or your attorney. This handbook is not meant to provide legal direction or advice and should not be taken as such. As a parent, you have rights, and it's important that you understand those rights. You have a right to be an active participant in the development of your case plan goals. You have a right to communicate with your child through visitation. This may be in the form of phone calls, letters, virtual visits, or in-person visits. In some circumstances, communication may be restricted or limited by a court order. As a parent, you also have the right to attend court dates and meetings associated with your family's involvement in the dependency system. You have a right to legal representation appointed to you or hired by you. You have a right to be respected regardless of race, religion, national origin, language, economic status, disability, gender, sexual orientation, or age. You have a right to receive a copy of the petition and all court-related documents pertaining to your case. You also have a right to be treated professionally, courteously, and respectfully by all child welfare and court staff. The courtroom can be an overwhelming experience, so we want to tell you who will be in court for your hearing. The people present at your first court hearing will most likely be the same people present for all of your hearings. These will include the judge, who presides over the courtroom and decides whether abuse or neglect has occurred and if the child needs to be monitored by Children and Family Services. Parent's attorney. Separate attorneys will be assigned to each parent. Children's attorney. The court will appoint an attorney to represent the children throughout the legal process. The child's attorney will explain things to the child and advocate in court for the child's desires, but also what's in the best interest of the child. County counsel will also be present. This is the attorney who represents Children and Family Services and brings the child abuse or neglect allegations before the court. A court-appointed special advocate, also known as a CASA, is a trained volunteer appointed by the court to represent the best interest of a court-dependent child. CASAs come from all walks of life with a variety of professional, educational, and ethnic backgrounds. CASAs ensure children involved with the dependency courts have a voice at all hearings. The first hearing is called a detention or an initial hearing. This hearing is usually held within 5 days of the agency making a decision to intervene. This may involve your child being removed from your care or not. Everyone in the courtroom, including yourself, will have gotten a copy of the detention report prior to this hearing. At this hearing, you'll be appointed an attorney, or you may provide your own. The judge will also appoint an attorney to represent your child at this time. The next few slides will give you more information about what to expect at this hearing. Whether you participate in person or via Zoom, you will be approached by several people who will need to gather some information. Some questions you may be asked will include your child's educational and medical history, your marital status, paternity, whereabouts of a missing parent, relatives or family friends who can offer support, your financial status, or information about your American Indian heritage. At the detention hearing, the court will also make some decisions about who will care for your child temporarily, how and when you will visit your child, paternity, the Indian Child Welfare Act, also known as ICWA, and when the next hearing will be held. You will be handed a copy and a chance to read all reports and memos prior to any hearings you may have. At the detention hearing, you will receive a packet that includes your report and petitions. The petitions are the first few pages in the report. These petitions are the legal documents prepared by the agency to describe the allegations of abuse and neglect. Some examples of abuse or neglect may include excessive physical discipline, exposure to domestic violence, bullying or belittling of children, failing to provide food, shelter, supervision, or medical care, exposing a child to parental substance abuse, sexual exploitation of a child, or allowing someone else to abuse or neglect your child. Approximately 30 days after the detention hearing, you will be asked to return to court for the jurisdiction and dispositional hearing, which will often be referred to as the J&D. This is an important hearing for your case because this is when the court will make decisions about the allegations against you and your family. The court will also decide what happens next. Next steps will be discussed in more detail on the next slide. At your second court hearing, the court may decide to order one or both of the parents family reunification services. This means your child will remain out of your home. The court may also decide to order family maintenance services, which would allow your child to remain in your care, but with continued court involvement. The third option the court may order is to bypass your services. This means the child will remain out of home care and the agency will be ordered to develop a long-term plan for your child. The long-term plan is also referred to as a permanent plan and can include adoption, legal guardianship, or long-term foster care. If the court orders family reunification or family maintenance services, you will be asked to participate in services. These services are detailed in a case plan. The case plan is intended to offer you and your family education, training, and support. You will have the opportunity to work with a social worker on developing your case plan and assist in determining what services your family is needing. Once your case plan is ordered by the courts, you will be expected to fully engage, participate, and learn from your services. You will be asked to talk about what you are learning from your services and how they are helping you and your family. If you are offered family maintenance or family reunification services, you will continue to have hearings every 6 months. These are called status review hearings. These are hearings where the court reviews your family's progress and makes decisions about next steps. If you are bypassed for services or your services are terminated, the court will schedule a permanency hearing. It is the permanency hearing where the court will decide whether adoption, legal guardianship, or long-term foster care is in the best interest of your child. During the life of your case, you may have several different types of social workers assigned to you. Social workers will be teaming together to ensure that your family's needs are being met. The emergency response social worker is the social worker who completed the investigation and interviewed you and your family. This is the social worker who wrote the detention report and will continue to work with you and your family until your next social worker is assigned. After the detention hearing, you will be assigned to one or more social workers. This usually includes a court social worker and/or an ongoing social worker. The court and ongoing social workers are often teamed together to meet you and your family's needs. A few days after the detention hearing, you will be contacted by your new social worker, who will schedule an appointment to meet with you in order to gather more information and to assist in developing your case plan. These social workers will also be writing the report and the recommendation for the jurisdiction and disposition hearing. After the jurisdiction and disposition hearing, your social worker will be meeting with you and your family at least one time per month. They will want to talk with you about what you are learning from your services, what you have accomplished, and about any struggles or obstacles that you are having. You may or may not have had a child and family team meeting already. If you have not had one will be scheduled for you and your family in the next 10 days. These are meetings that are centered around you and your family, where we ask you to bring important people who care and support you and your child. Major decisions are made during these meetings, so it's important that you participate and bring people who can support you and your child during this transition. Many of the decisions made during these meetings will include who will care for your child, visitation issues and schedules, creating safety for your child, increasing or changing visitation, obstacles and struggles your child may be having, and long-term plans. Ideally, as your case progresses, you would add supportive people to these meetings to show that you have a natural support system in place. This support system will continue to help you and your child even after the case is closed. At a children and family team meeting, you can expect a strength-based approach to find out how to help your family. You should expect a clearly stated goal for each meeting, and you should expect your team to brainstorm options and action steps. You should also expect all team members will agree to complete specific tasks and responsibilities. Your role at a child and family team meeting is at the center of this process and the most important part of the team. You should attend every meeting as part of your plan so that your team can hear from you and your child directly. The team needs and wants to hear what you have to say. Share your opinions, thoughts, and concerns. Family time will be coordinated with your social worker, and each case will be handled differently based on your family's circumstances. Talk with your family and friends about supervising some of your visits. If someone is interested in supervising your visits, you should talk to your assigned social worker to see if they can be approved. If the child is placed out of home, you may have supervised, monitored, or even unsupervised visits with your child. If you are unsure about the visitation rules, please talk with your social worker. Supervised visits means your interactions are observed and someone is within hearing distance of you and your child at all times. The person supervising might offer some coaching, mentoring during the visits. Monitored. This means that your child will have some alone time with you. Someone will need to be nearby and checking in every 20 minutes to offer support and ensure safety. Unsupervised. This means that you do not need to have an outside person involved in your visits. There are some things that you can be doing on day one to show that you are ready to make positive changes. You can advocate for yourself, stay organized, attend and arrive on time for meetings and court hearings, participate in all decisions about your child, build respectful, positive relationships with people, stay in touch with your child, stay in touch with the people caring for your child, be available to make medical decisions for your child, participate in your child's education planning, and work on your case plan goals. Support is a key part to child safety, but support is necessary for everyone. We all need it, especially during times of stress or when we or the people we love are involved in a crisis. No matter what you are going through, you are not alone. Supportive individuals and organizations are all around you. Family member, friends, and specific organizations can offer direct support. These can include direct counseling, one-on-one conversations, groups, family peer contacts, and information and referrals. Some examples to consider are your church or religious group, your local counseling or community center, your friends and neighbors, your extended family network, helpline and support groups, and community resources. Listed below are a few resources, which include substance abuse, Al-Anon, AA, and NA, domestic violence resources, which include the Coalition for Family Harmony, Domestic Violence Hotline, Sexual Assault and the Rape Hotline, and Interface in Children and Family Services. Ventura County Behavioral Health Services, National Suicide Prevention Hotline, and National Alliance on Mental Health Helpline. General Relief, Court Information, Parent Education, and Homeless Services. Thank you, and remember, don't be afraid to ask questions and communicate your needs to your social worker and your attorney.